While the concept of natural rights and human rights may seem rather odd and contested within the world of philosophers and political scientists and not fully understood by most of us, its impact has been huge. Natural rights, or the equality of all humans to share certain inalienable or natural human rights, has led to constitutionalism. The idea that societies, political societies, are bound together, political systems that is, are bound together by rights and obligations, which leads on to notions of the separation of powers and checks and balances, of the rule of law, that all human beings are governed by certain principles of law, the most essential of which is that no one's above the law, be they kings or princes or aristocrats. They are equal in the eyes of the law. With those two ideas comes the idea of limited government. The government should be itself subject to the law and subject to certain constraints. Well, that you're describing there is the foundational ideas of liberal democracy. Although democracy comes along a little bit later, not always seen as such a universal human right, at least not initially. Certainly ideas of constitutionalism and human rights precede democracy, which tends to lag behind. Well, bills of rights tend to come in two sizes or flavors. First, there's the kind of Bill of Rights or Human Rights Declaration that is advisory. It sits as a kind of benchmark of how we should all behave, how nations should behave, and how nations might judge themselves and judge each other. And the most famous of those, I would imagine, would be the Universal Declaration of Human Rights by the United Nations, declared in Paris in 1948, and the result of work of a committee of the UN, led by Eleanor Roosevelt, produced a statement of universal human rights. Well, again, it might be open to the accusation that these are rather Western rights. They certainly contain all the things that any Enlightenment philosopher might recognize, Thomas Jefferson or John Locke, rights of liberty and freedom of movement and freedom of expression and so on. All those things would be there: freedom from torture, people to be treated fairly under the law, and so rights of expression, rights of religious expression, and so on. Also in Article 25, or Section 25 of the Universal Declaration, other rights to a dignified life, which include things like education and health and housing. That leads me to the other kind then of human rights declaration, which are those which are judiciable. So we've got the advisory kind and the judiciable kind. Now, the judiciable kind can be enforced in the courts in some way. They have some kind of legal process where people can seek redress for not having those rights observed or respected, or having them transgressed. And you might argue that the United Nations, since there is an International Court of Justice in The Hague, one of the principal agencies of the United Nations, this might be the judiciable organ of the Universal Declaration, but it isn't really. The International Court of Justice in The Hague, the UN body, is essentially a court of arbitration. If its judgments are enforceable or accepted, it is by a voluntary process. Nations accept that they are participants within a judgment of the International Court of Justice, and the International Court of Justice draws upon a broad range of legal practice and history, although it may be influenced by the Universal Declaration of Human Rights. Nonetheless, it doesn't have the same relationship that the European Convention on Human Rights has with the European Court of Human Rights and the European Council. That system, which was set up shortly after the UN in 1951, it's drafted in 1953, the British accept it, and the European Convention on Human Rights is a judiciable rights system of rights. You can have judgments enforced, and those who sign up to the Council of Europe, the memberships of 46 countries, I think, are currently members of the European Council, they will accept its judgments and are bound by the judgments of the European Court of Human Rights. Well, the drafting of the European Convention on Human Rights contains many of the things that John Locke or others would recognize, or people drafting the UN Declaration of Human Rights would recognize: freedoms of speech and freedom of family life and so on, freedom of religion and freedom to participate and so forth, and freedom from torture and freedom from slavery, and all those things contained within the European Convention on Human Rights. It was drafted primarily by British jurists, and that indicates, in a way, Britain's relationship with the European Convention on Human Rights is that the British, very significant in their influence on its design and its wording and its content, felt very much the spirit was that the British were designing a set of rights which to be observed by, well, observed by themselves, but they thought they did that anyway. This was very much a lesson to other countries in the sorts of rights that British people naturally enjoyed. That was very much the spirit of the early 90s and Britain's relationship with the European Convention on Human Rights. It was, in a sense, it was for Europeans to avoid the kind of awful tyranny of their own people in totalitarian regimes, which had been the lesson of the 1920s and 1930s. It was, in other words, to avoid that which had happened, the Holocaust, the appalling treatment of citizens by fascist regimes, and the avoidance of the emergence of fascist regimes. So the Council of Europe was going to monitor and going to be the principal human rights organization for observing how states observed, how states developed, and how states protected and produced reports and monitor. It'd be a watchdog, in other words, of human rights across Europe to avoid that which had occurred in the Second World War and prior to the Second World War, with the emergence of fascism. So it was the European Council as the watchdog, the European Court as the enforcer, and the European Declaration of Human Rights as a list of rights to be observed by all members, including Britain. Although Britain initially didn't allow its citizens, it opted out of the feature where its citizens could appeal directly to the European Court of Human Rights. This didn't occur until 1966. Again, because it was generally thought that British citizens were well enough protected by common law, an independent judiciary, and a long tradition of rights that other European countries had not had so clearly, weren't lucky enough to benefit from. Well, in 1966, things changed somewhat. Attitudes in Britain were changing. The 1960s were changing attitudes. Social attitudes were changing. There was a Labour government in power. It was a reformist government. And one of the things it wanted to do was be somewhat more European. It wanted to join the European community. It wanted to be more in line with standards of human rights that were seen across Europe, at least partly to avoid criticism. Other countries had adopted the European Convention on Human Rights into their own law. Britain thought of doing that, writing a Bill of Rights that would be based upon the European Convention of Human Rights, or incorporating it into British law, which they didn't do. But instead, they allowed British citizens to appeal to the European Court of Human Rights. However, that was extremely limited by the fact that they would have to exhaust all domestic law first. So you'd have to go through all the systems of application for judicial review, or your court case heard and appeals heard, and all the way up to the Committee of the House of Lords, which was the precursor of the Supreme Court in this country, and then on to the European Court. So again, it was thought that this would filter out almost everybody. The British courts would satisfy most people's desire for redress. So very few cases would go, but it certainly was something the Brits, 1966, wished to show to the world that they were willing to do, willing to allow. Well, surprisingly, there were quite a few cases that Britain lost to do with the treatment of people in Northern Ireland, particularly in detained prisoners who were, well, basically tortured, sensory deprivation, stress positions, hooding of prisoners and so on, and corporal punishment in Scotland, and other cases. Britain lost a number of cases. So this sense in which the British judiciary was a little out of touch, you can see, by the way, as a digression, in the late 1950s, early 60s, I think it was 61, the Lady Chatterley trial, where the judge instructs the jury at the end of the trial, should Lady Chatterley, the book Lady Chatterley, D.H. Lawrence novel, certainly seen as rather risque at the time, turned to the jury and said, was this something you'd want your wife or your servants to read? In other words, by the 1960s, there was a real feeling the British judiciary could do with a bit of updating. It wouldn't be a bad thing to be a little more European and a little more emphatic statement of rights. That wasn't really expected that many British people would need it. Surprisingly, Britain finds itself in the subsequent years from 1966 onwards to have lost quite a few cases, more than other European countries, which, having incorporated the European Convention of Human Rights into their law, found that these were dealt with domestically. So Britain was rather embarrassed by the fact that the European Court of Human Rights had found so many cases against Britain that was so proud of its own legal system, archaic though it might have been, and so on, and beset with all sorts of problems of class bias and gender bias and so forth. So there are two kinds of bills of rights: the justiciable kind, the European Convention on Human Rights, the advisory kind, the benchmarking kind, the Universal Declaration of Human Rights by the UN. You could subdivide the kinds of rights that bills of rights have within them as being those kinds which are largely negative. There are those rights which protect you from things, allow you to get on with things uninterrupted. Freedom of speech, freedom of religion. You can do that yourself. You should be protected from others interfering with you. These are sometimes described as negative rights. I think it was Isaiah Berlin, his concept of negative and positive rights. And the positive rights, those things you require other people to provide for you: housing, education, welfare, these rights. And so the European Convention on Human Rights contained things like right to a family life. And simply being left alone didn't necessarily mean that you could enjoy a right to a family life. So the European Convention on Human Rights was of that kind of Bill of Rights. Like the UN Bill of Rights, that contained positive and negative rights. Now, by the way, positive and negative rights certainly overlap. It's not dead clear that they can be so easily separated. To enjoy freedom or freedom of speech isn't simply to be left alone to speak. You might well be excluded by mechanisms such as not having access to the press, or there not being available a means by which you can promote your ideas and so on. It's all very well having freedom of speech, but if you are shouted down by the enormous power of money and a much louder megaphone that provides, you don't really have freedom of speech. So positive and negative rights. And there is a collision, of course, between the kinds of freedom that those represent, most notably by the Second Amendment in the United States. The right to have guns, to be left alone to enjoy your own guns, might well infringe upon people's rights to peaceful existence and not to be shot by an angry neighbor or child finding the gun in your bedside drawer. So safety and security, you can find the arguments on both sides of the Second Amendment. The Bill of Rights in the United States is a good example which errs towards negative rights. Those things sort of, it's principally to be sort of left alone, although it has developed into a whole series of positive rights. So those kinds of bills of rights, ones that outline broad principles of liberty, and those that outline broader principles of rights of access to certain services, might well form another way of understanding human rights and rights acts.